Hello, future travelers. Welcome back to Legalopolis, where we simplify complex immigration topics for you. In today's video, we are exploring the latest changes to the H1B program that took effect on 17th January 2025. Whether you are an H1B applicant, an employer, or a student on F1 visa who's planning to transition to an H1B visa, we've got you covered. We'll break everything into clear, simple points to ensure you're fully prepared. And so, let's get started. Now, friends, first let's understand the purpose of the changes. Friends, through these changes, the Department of Homeland Security wants to achieve three main goals. Number one, clarify the requirement for H1B eligibility and make the process smoother. Number two, provide greater flexibility and benefits for everyone involved, that is, employers, workers, and students. And number three, strengthen the integrity of the program to ensure fairness and accountability. Now let's look at the changes that have taken effect. The first change is new Form I-129. So friends, from now onwards, a new version of Form I-129, that is petition for a non-immigrant worker, will be mandatory. This updated form is specifically designed to implement the final rules for the H1B program, as we will learn now, ensuring compliance with the latest regulations. The second change is about the revised definition of H1B specialty occupation. Friends, through the new rule, DHS clarifies what counts as a specialty occupation. Employers no longer have to prove that a specific degree is always required for the job. Normally is enough. But here's the catch. If the employer accepts multiple degrees for the position, those degrees must be directly related to the job duties. This gives employers a little more room to qualify jobs while maintaining the program standards. And directly related means that there must be a logical connection between the degree and the job. And if an H1B worker is assigned to a third-party worksite, then DHS clarifies that the third party's requirements will determine whether the job qualifies as a specialty occupation, not just the petitioners. The third change is deference to previous approvals. Now friends, USCIS will now give more weight to previously approved cases when processing new applications for the same job and the same applicant. They'll only question prior approvals if there is a material change, error, or new adverse information. This means that the adjudicators are now encouraged to defer to prior USCIS approvals when the case facts haven't changed, cutting down on unnecessary reviews. Then we move on to the fourth change. Clear rules for job location changes. Now friends, here if an H1B worker's job location changes significantly, employers must file an amendment before the change. However, moves within the same geographic area that is listed in the LCA, that won't require any amendments. The fifth change is for business owners. Business owners with controlling stakes can also qualify for H1B status. However, their initial and first extension approvals will be limited to 18 months instead of the usual 3 years. So what this guideline means is that if the beneficiary has a controlling interest in the petitioning company, then they will be allowed to apply for and qualify for H1B status. However, both the initial petition and the first extension will be limited to 18 months each to ensure proper oversight. The sixth change is a strengthened cap protection for F1 students. Friends, under the new rule, F1 students with timely and non-frivolous H1B change of status petitions can now benefit from an extended cap period lasting from October 1st up to April 1st of the following year. This provides up to 6 additional months of status and work authorization, ensuring a seamless transition to H1B without any gaps in legal status or employment, which would be a significant relief for international students transitioning to H1B. The seventh change is focus on bona fide job offers. Friends, employers must prove that the job offer is genuine, but they no longer need to show detailed day to day assignments for the entire H1B period. So, this rule removes the outdated itinerary requirement for petitions. So, what was the itinerary requirement? It was a rule that employers had to follow when filing an H1B petition, especially if the employee was going to work at multiple locations. Basically, the employer had to submit a detailed itinerary listing exact dates the employee would be at each location, specific work locations, a description of job duties, etc., which was a nightmare and significantly increased the administrative work. But the good news is that now it is a thing of the past. The government recognized that in today's dynamic work environment, expecting employers to predict every little detail of an employee's work schedule is unrealistic. And this change makes the process smoother and more aligned with the realities of today's work environment. The eighth change is as regards updates to petition validity periods. Employers can request an amendment to the H1B validity period if the original requested period has expired during USCIS adjudication. Now, if the current LCA doesn't cover the new validity period, the employers must submit a new LCA, meet the higher of the prevailing or actual wage requirement, but they cannot lower the offered wage below the amount in the original petition. The ninth change is site visit program has been codified. Now friends, the new rule formalizes USCIS's site visit program under the Fraud Detection and National Security Unit, granting DHS the authority to conduct site visits at any location tied to H1B employment, including current, past or future work sites and third-party locations. Refusal to comply with a site visit may lead to petition denial or revocation. And we come to the last change, expanded cap exemption. Now here's some great news for non-profit and government research organizations. DHS has updated the definition of these entities to include organizations where research is a fundamental activity even if it's not their primary mission. This means more flexibility for cap exemptions. And so, non-profits and governmental research organizations, as well as non-profits tied to educational institutions, can qualify for cap exemptions even if their primary mission isn't research or education, as long as it's their fundamental activity. So friends, in summary, these changes are all about making the H1B program more flexible, modern, and fair while maintaining strong integrity measures. For workers, it means fewer disruptions in status and employment. For employers, it means a streamlined process and clearer routes. So friends, if you found this breakdown helpful, don't forget to like, share, and please consider subscribing for more simplified updates on immigration, visas, and more. Thank you for watching, and as always, take care, stay informed, and safe travels!